Oh, we're recording? Hi, Michael Mincelli here, civil rights advocate, humanitarian for Truth Ministries, uh, TMI, Truth Ministries Incorporated. Thank God in America for free speech. We're here to talk about some ongoing pro se cases that are active and ongoing in order to protect uh, civil rights of real flesh and blood human beings according to the Constitution. And our first video explained pretty much how we got started in foreclosure cases. But for those who do not know or just tuning in, TMI, Truth Ministries Incorporated, wants to build 2-story buildings across Florida, where the first floor is a business, for-profit, restaurant, etc., and the second floor houses homeless for up to 6 months. After the 6 months, the person stays in that facility and works downstairs. They get a check for about $6,000 or $7,000, an apartment and a car, and pointed in the direction of a church, if they want to go, that fits their profile. So with that being said, we ventured out to figure out how we can finance these buildings without loans or private investors that are just money oriented and bottom line driven. So we saw that there was a big crisis in the foreclosure market, and people were losing their homes no matter what situation they were in. It didn't seem to matter to the local clerk of courts. And the judges were siding in the bank's favor 99% of the time, regardless of the situation. Lawyers were just buying time, and people were, at the end of the day, were still losing their homes. Okay, so we ventured out to help pro se litigants, people that are representing themselves in court in foreclosure cases, okay, in the county clerk of court. Let's start with a case now, ongoing, okay, in Florida. We're going to keep the names protected in the ongoing cases because they're open. We're going to call this the case of Two Scoops. The case of Two Scoops. All right, so in the case of Two Scoops, we have a gentleman that was being foreclosed on the local clerk because he didn't make his payments. Okay, and we're going to go ahead and not protect the bank's name in this because they're a public corporation anyway, and they have so many ongoing cases that they wouldn't be able to find Two Scoops now. So anyway, this is going to be for Green Tree. Green Tree Mortgage Servicing. Okay, they're foreclosing on Two Scoops. And Two Scoops didn't want to lose the home. He's been there 30 years. 30 years. Raised his family. And that's the place he wanted to live and live his last days out in. But anyway. Okay, so foreclosure is filed. Trial is set. Okay, so we all know bankruptcy stops trial. So he went ahead and did a bankruptcy, stopped his trial. The trial started in March. We were able to postpone it, and then he postponed it with a bankruptcy in March. Okay, and then came out of bankruptcy, let's say in April, May, June, July, about August. Okay, then the lawyer in that particular case that was representing Green Tree wrote a motion to the judge saying because nothing has changed since the last trial date, can he go ahead and grant the final judgment of foreclosure and set a sale date? And this particular judge, he did. So without a trial ever taking place, the trial that did take place, Two Scoops went in with the bankruptcy papers, and they had to stop the trial because of the stay that was pending in the bankruptcy court with the open case. So anyway, so that was stopped, and then months later, the lawyer writes a motion requesting that the judge, without the trial, foreclose. And he did. He put a final judgment of foreclosure and set a sale date. Okay, so prior to that, Two Scoops put in a demand for dismissal or state the proper jurisdiction, meaning this for all you that do not know. The local county clerks have what they call general jurisdiction, okay? So what you have to do, or what they have to do, if you challenge that jurisdiction in a civil case especially, they have to state that proper jurisdiction to you. It's what they call a threshold issue, meaning that everything must stop until they answer that question, meaning when you challenge the jurisdiction, stating that the court does not have jurisdiction to hear the case or make any sort of judgment in the case, the court, have to stop the process and state or explain to you in writing how, in fact, they do have the jurisdiction in order to make that final judgment. Okay. So, in the case of Two Scoops, after he stopped the trial with the bankruptcy, he submitted a demand for dismissal or state the proper jurisdiction. And that was somehow taken as a motion to the judge and denied. So, just in case it was an error on their behalf, Two Scoops put another one in. And they ignored that. So they went on with their proceedings to go ahead and later on adjudicate the foreclosure without the trial and sell the property. Okay, so that leads us to the judge not stating the proper jurisdiction when it was what they call challenged, which is a big no-no. Okay, so long story short, after two of the challenging the jurisdiction that was put into the judge and him overlooking it, then doing the final judgment and then selling the house to, by the way, a Fannie Mae program for $28,400 when the house had a lien on it for about $67,000 and was only worth $42,000. So that's a complete different video. But if you can make sense of that, you know, you're very much with it. But anyway, long story short, after the judge did not state the proper jurisdiction, put a final judgment of foreclosure, sold the property to the Fannie Mae program that was upside down for somehow a cash sale amount of $28,400, Mr. Two Scoops put in what they call a breach of trust with fraudulent intent petition. Okay, now that into the county case. Now the judge did not yet answer that petition. Therefore, Mr. Two Scoops put a notice of appeal in based on the judge not having the jurisdiction. Now, when he put that notice of appeal into the clerk, he asked the clerk to attach not only the petition, but the final judgment. So the clerk took the notice of appeal, took the final judgment that you're supposed to copy. For all those who don't know, that when you put a notice of appeal in, you're supposed to attach a copy of the final judgment that you're actually appealing. Okay, so Mr. Two Scoops goes into the clerk and submits his notice of appeal with his petition and the final judgment that he is appealing. And the clerk at this local county court, which we're going to leave names out, okay, ongoing cases, decided to give Mr. Two Scoops his paperwork back that were attached to the notice of appeal, which were not only the petition, but also the final judgment, which you're supposed to, according to their local procedure and rules, attach to the notice of appeal. Okay, so Mr. Two Scoops hands back the clerk the final judgment with the petition and asks the clerk to please make sure the copy of that is attached to the notice of appeal that she's forwarding to the appellate court. Now, long story short, about 2 weeks later, the appellate court receives the notice of appeal and opens up a case, but then requests that the final judgment be put into the appellate because there was no final judgment that was attached to the notice of appeal, or else they will dismiss the case within 10 days. Now, this only can happen one way. The clerk that took that final judgment discarded the paperwork and only turned in the notice of appeal. Now, what were her intentions in doing so? We do not know. There's only two answers. One, either she misplaced them or threw them out or didn't know after being told they needed to be attached and forgot them somewhere or something on an accidental, I don't know, basis. I don't even know how to say that. But or she knew that the appellate court would need that final judgment, which is her job to know, by the way, and wanted to make sure it wasn't there with hopes that maybe they wouldn't open up this appellate case. So that's where we're at with Two Scoops. Now, the petition is incredible, okay? And the challenging the jurisdiction is true and correct and every right of every real flesh and blood United States citizen. And the fact that when I say real flesh and blood means that there's a difference. There's something other than real flesh and blood United States citizen appalls me. And there's a difference between you and the name that the court uses. There's a difference between you, the person listening to this, and the name that's on your driver's license. There's a difference between you and any name that's on your property tax information. Even on your FPL bill, even on your water bill, your utilities. There's a difference between you and that name. And here's the difference, okay? One is real flesh and blood. That's you. That's you. Real flesh and blood. You walking around, and that's it. Okay? And that you has rights according to the Constitution. All right? Now, the other you is on your driver's license. If you look at it right now, if you take it out, you're going to notice that all the letters in your name are capital, that your whole name is capital. Now, I know if you went to school in the United States, and I think pretty much in the world, but I know in the United States, because that's where I went to school, that they taught me to spell my name. Capital, the first letter. The rest, lowercase. Middle initial, capital. Last name, first letter, capital. Rest, lowercase. Okay. And I know you probably were taught the same way. So it has to make you wonder why on your bank account is your name capital? Why on your driver's license is your name capital? Why, when the court sends you any sort of documents, is your name capital? What is the meaning for that? Did they mess up? Did they make a mistake across the country on every different piece of paper that they're addressing to you from the courts or from any business or from FPL or your power company or your water company or your local DMV, Department of Motor Vehicles? No, they did it on purpose. Okay. The reason why is this. Okay. You as a real flesh and blood person have constitutional rights. Now, when you answer to your capital name, that's a corporate name. And what that means is it's governed by what they call corporate law, which is also statute law. That's the same statute that governs your laws of driving, your laws of local courts. They're not going by constitutional rights. The Constitution does not even apply to you there. Matter of fact, when you use anything that has your capital name, you're waiving your constitutional rights. And you're saying, you're giving that person, whoever's telling you that you can drive with that license, or when you walk into the court and that person sent you a letter with your capital name and asked you to come into that court, when you come into that court and you answer to that capital name, you are giving them what they call jurisdiction. And that jurisdiction is now governed by what they call statute law. Okay. Now, the only way that they can govern you with that statute law is if you consent to it, if you give them jurisdiction. Now, how do you give them jurisdiction? Well, that's simple. Okay. Anything but challenging that jurisdiction is giving them the authority to rule over you by statute law, which allows, is you waiving your constitutional rights. Okay, now what is the Constitution? The Constitution was founded by our forefathers of this country to make sure that all people were equal and equally free to pursue happiness and life, liberty and justice. Okay. Now I'll leave it to the rest. I don't have to go into a whole constitutional educational seminar on what the Constitution is there for. We all know it's there for the people, by the people, for we the people. Real flesh and blood. Matter of fact, if you go to the U.S. Marshals website, you'll see that they spell United States of America correct. With a capital U, lowercase the rest. So on and so forth, okay? When you go on to the county clerks, you'll see that they capitalize everything. The name of the county clerk to the state that is coming against you or that it's governing. Even in Florida, the state of Florida would be capital. In Hernando County, the Hernando County clerk and all its paperwork will be capital because it's statute law. It's not governed by Constitution. So it's not real flesh and blood. So for real flesh and blood. Now, how do I separate that on paper? Well, simple. Real flesh and blood is you, the way your teachers taught you to spell your name. That's your real flesh and blood name. That's you. That's that name, the way it's spelled, has constitutional rights. Okay? What doesn't is your name spelled any other way that's not according to the Constitution. And that would be all in capital. Okay, and that allows, that's you. If you adhere to that name, then you're giving up your constitutional rights, period, point blank. All right, now, in a foreclosure case, when they send you the paperwork because you're living in the property, you really have no choice but to respond, because if you don't respond, that's also giving them jurisdiction. And they're just going to go ahead and have a trial and take your home, okay? Then if you respond, then you're governed by statute law, and they're still going to go ahead and foreclose on your home, kick you out on the street, and take your home, okay? So it's a catch-22. No, it's not, all right? All you got to do is challenge a jurisdiction. How do you do that? There's a proper way to do that. Now, if you call me, 727-815, I'll tell you more about it. Other than that, it's going to be on the next seminar or tape or notes, however you want to call this. This is TMI, Truth Ministries Incorporated, in order to guide the poor, the oppressed, and the afflicted with the spirit of truth in the name of Jesus, according to his will on earth as it is done in heaven. Now, challenge jurisdiction when it comes to losing your home. Call me. We'll guide you more, or you can visit us on the website we're about to have. Anyway, listen, it was a pleasure talking to you. God bless you. God bless America. And have a good evening.